Hi, I'm Laura, a virtual HR consultant for Key HR. This mini webinar will help you understand some of the common errors employers make that result in them ending up in employment tribunals. Number 1. Failure to properly investigate. As an employer, it is paramount that you undertake a proper formal investigation to establish all the facts prior to taking any disciplinary action. This investigation will form the basis as to whether there is enough evidence to warrant taking disciplinary action. Anyone who is talked to as part of the investigation should be advised it is confidential. If you are unable to demonstrate that you have properly investigated all the facts, your dismissal may be deemed to be unfair in a court of law. Number 2. Failure to follow a recognized disciplinary procedure. It is a legal requirement for all businesses that employ staff to have in place a formal disciplinary policy and process. The only thing worse than not having in place a formal disciplinary policy is having one and failing to follow it. The purpose of a formal disciplinary process is to provide a legally compliant framework so that both employers and employees know what will happen and protects both parties. Failure to have and follow a formal disciplinary process will result in most tribunal claims being lost by the employer, plus any tribunal award automatically given to the employee being increased by up to 25%. Number 3. Using the wrong people in the process. In order to ensure openness and fairness, the courts require that different people do the investigation, disciplinary hearing, and appeal hearing. Ideally, the structure should be: the investigation meeting should be undertaken by the employee's line manager. The disciplinary meeting should ideally be undertaken by the next level of management. The employee's appeal should be heard by a senior manager or company director. Whilst this is easy to do in large organizations, it can be harder in smaller companies. Consider using managers at the same level for the investigation and the disciplinary meeting. However, never use the same person for more than one meeting, as the courts will see the process as being unfair and biased. Number 4. Not setting out and providing details of the allegations prior to the meeting. As an employer, it is very tempting to call an employee into a meeting and start to address either performance or misconduct issues immediately with an employee. Whilst this is fine if you are addressing matters on an informal basis. However, should you wish to take formal disciplinary action, this approach would be in breach of current legislative guidelines, resulting in you losing a claim should one be brought at tribunal. As an employer, you have a legal obligation to provide the employee with all the details of the allegations against them in writing, prior to the meeting. You also have to ensure that they have sufficient time to read the information and prepare a defense for the meeting. Number 5. Failure to suspend an employee. In cases of serious misconduct and gross misconduct, employees should always be suspended, on full pay, pending the outcome of the investigation and disciplinary hearing. As an employer, it's all too tempting to either allow the employee to keep working if you are having to pay them, or suspend them on an unpaid basis. In both cases, you are leaving yourself open to tribunal claims. Firstly, you will not be able to argue there was a fundamental breach of contract, as you allowed the employee to keep working, and therefore have accepted their behavior. Secondly, the employee will have the right to take a claim for unlawful deduction of wages, which gives them an automatic right to take tribunal action without any qualifying period. Number 6. Not allowing the employee to have representation. Any employee involved in disciplinary action has the legal right to representation in any of the meetings associated with the disciplinary process. They may be accompanied by either a work colleague or trade union representative. Even if your organization does not recognize a trade union, if the employee is a member of an external trade union, they still have the right for them to attend. Any disciplinary action taken without allowing the employee proper representation will be automatically unfair, and any award given at tribunal will be increased by up to 25%. Number 7. Failure to inform employees of possible outcomes in advance. Whilst it is illegal to make a decision prior to holding a disciplinary meeting, all employers are legally required to inform employees in writing of the potential outcome of a disciplinary meeting before it takes place. The phrasing of this notification is paramount. If phrased incorrectly, the employee may be able to demonstrate that you had made a decision prior to holding the meeting, resulting in any dismissal then being deemed automatically unfair by a tribunal. Failure to notify an employee of the possible outcome prior to the meeting will result in any disciplinary action or termination being unfair. Plus, any tribunal award could be increased by up to 25%. Number 8. Not investigating additional points raised. As part of the disciplinary meeting, the employee may raise additional information or points that cannot be substantiated then and there. As an employer, it is all too easy to dismiss these points and proceed with the disciplinary process, as you want to save time and money. Failure to place the employee back onto paid suspension and investigate the additional points may result in the dismissal being deemed to be unfair in a tribunal. Number 9. Failing to follow the right meeting structure. When undertaking a disciplinary meeting, there is a set legal format that needs to be followed to ensure fairness, legality, and transparency. This structured approach is not merely a formality, it is crucial to maintaining the integrity of the disciplinary process. Something as simple as not having a break at the right time or not taking proper notes could result in a dismissal being deemed unfair by a tribunal. Number 10. Not allowing the employee to appeal. All employees must be given the right to appeal against any disciplinary action taken against them. The appeal meeting should be undertaken by someone independent and not involved in the original investigation or disciplinary process. Failure to give an employee the right to appeal will result in any termination being deemed to be unfair by a tribunal and would result in an additional uplift of 25% in any award. Adhering to the correct disciplinary meeting procedures is essential for ensuring fairness, transparency, and legal compliance. It is highly advisable to seek professional advice throughout this process to ensure all legal requirements are met and to mitigate risks. Professional advice can be particularly valuable when preparing for the meeting, handling complex cases, or when there are uncertainties about the procedures. Failing to follow these guidelines and not seeking professional advice can result in tribunal claims, increased awards, and reputational damage. Properly managing disciplinary procedures, with the support of professional guidance, protects both the organization and its employees. Contact us today for a free consultation. At KeyHR, we specialize in providing comprehensive solutions for employers navigating disciplinary actions, offering expert advice and guidance every step of the way. Provision of legally compliant disciplinary procedures. Supplying all requisite letters and documents to support the process. Alternatively, KeyHR can undertake the whole disciplinary procedure on your behalf, ensuring legal compliance and limit the chances of future claims. Give us a call today.